If you're applying for disability benefits or help people that are, the path to success has never been more complicated. Welcome to the Disability Expert Podcast, where we tackle the difficult issues and interview the country's top experts to help you better navigate the disability process. Winning a disability case is hard and keeps getting tougher every day. We can't promise you'll win your case by listening, but we sure think it's going to help.
This really isn't that complicated. I mean, you want to win your case, don't you? Well, then listen to what I say.
Hey, welcome to the Disability Expert Podcast. I'm Chad Brown. I'm your host. I'm so excited today to have Heather Liles as my guest. Heather, how are you doing?
I'm good. How are you?
I'm doing great. Thanks for being on the show. Good to see you again. Tell you a little bit about Heather. For those of you who don't know her, she, for the last 10 years, has headed the disability section for George Sink Injury Lawyers, which is probably the largest personal injury law firm in the state of South Carolina. Done tremendous amount of disability work over the years. Graduate New England School of Law back in 2009, graduated University of Kentucky in 2006. Has worked exclusively in the Social Security disability space since 2014. I believe she's in the North Charleston
Yes.
office in Charleston, South Carolina, where I lived in the Johns Island technically, but we were in Charleston for about 5 years, and that's when you and I became friends. So it's very good to see you again.
Good to see you too.
Disability expert, and excited to talk to you.
I'm excited to be here.
Let's talk a little bit about initially how you got into the practice of disability law, how you ended up with George Sink. You guys have big disability practice, do a lot of work, helped a lot of people in the low country as well as across South Carolina. So how did you end up there?
So I actually, when I left Boston, I'd taken the Massachusetts bar. So I came down to Charleston to wait out my results. My sister had just had a baby, my nephew Wyatt, and a big military area here. So I was here because of the Air Force. But I decided, even though I passed the Massachusetts bar, that I was not going to leave. A little too cold for me. So I decided to start working in the legal space here and sort of break my way in before I took the South Carolina bar. I didn't end up having to take the South Carolina bar, thank goodness, since at that time it was that 3-day monster exam.
Yeah, sure.
But I ended up getting placed at a firm and leaving with someone who went to George Sink. And they said that they were looking for somebody to head their, work in their Social Security department. And luckily I had a Massachusetts license and a federal license. So I was able to, start working in the disability practice there. And I've been there ever since.
Yeah, it's interesting. Aaron Dalton, who does our federal court work, is licensed in South Carolina, but he was able to waive in from North Carolina because now, depending on what state you're in, a lot of states you can waive in. But obviously, in the disability space, you don't have to be licensed in the state to practice, at least at the admin level, where you guys spend most of your work. I know just from our conversations that one of the things you really pride yourself on is preparing your clients for hearing. I think sometimes people who only have ever been experienced with court, say you've only been to court for a traffic ticket, or you've never really been in a sort of a life-changing event, don't appreciate that in disability space, when you have your hearing, a lot of times it's the most important day of your life. You've lost your ability to have income, you have significant medical problems that are physical or emotional, and you need the insurance that comes with that. Your life becomes unstable, and all of a sudden you're like, oh, that's fine, we're going to have a judge, and you have to have this hearing. And, I know you have always done a great job preparing your clients for hearing. So what I want to do today, if we can, is something a little different than what we normally do on the podcast. We actually go through and talk about what does an expert do when you're preparing your clients for hearing? What are you doing to help sort of relieve their stress and frame their case in such a way that they have the greatest chance of winning? So let's just talk a little bit about the questions that your clients have. So okay. I know when our clients come in, one of the things they say about the hearing is, first, I don't want to have a hearing. Why do we have to have a hearing at all, right? And then what are they going to ask me in the hearing? So let's just start there.
Okay.
Why do clients need to actually do the hearing, and what should they expect from the judge's side when they get it started?
Well, I'll start with why they need to actually do the hearing. This is the first time, and I know for many of my clients, they are itching from day one when I sign them to tell their story. This is the first time that they're actually going to tell their story in person to an actual physical human being. They've told their doctors, I'm sure they've told their friends and family, but this is the first time that somebody who's going to be actually reviewing their case is going to hear their side of the story. Because unless you have somebody in there looking at you every day when you're at your house or with you all the time, they're not going to know how those disabilities affect those people on a day-to-day basis. So the hearing's really the first time. And obviously I want my clients to be approved before the hearing and not have to go through it. But I'm happy that they do have to go through it because at least, they can tell a live person what's been going on. Reading medical records, looking at a file, you're not not going to get any of that from just doing that. So what I actually do with my clients is I do sort of what's called a hearing prep, but it's really just like a little mini trial where I prepare them for what's going to come at the hearing. And we start all the way from the day of what's going to happen, what I should wear, what I should bring, what the judge is going to talk to me about. So the first thing I usually say is, there's going to be 5 people in the room that day, you and me and the judge, a court reporter who's going to be recording everything, and then a vocational expert. And then I usually go through, how to answer questions, what questions that are going to be asked of my client, what the vocational expert is going to say, and then, what's going to happen after the hearing. So we sort of do what's called a mini trial prep right before. We do it about a month out.
One of the things that, we sort of over the years have come to realize is a lot of times they're like, well, why do I have to have a hearing? Isn't my evidence? Don't they have my medical records? And they fail to understand that being disabled is not about carrying a diagnosis. Being disabled in the Social Security context is about being able to demonstrate that the diagnosis produces limitations and impairment-related limitations, and those limitations impact your ability to work. And so there's a bridge there that has to be met, and you can't meet that bridge in the medical records usually. And the hearing is really something they should be thankful for, because usually the case isn't strong enough to meet that bridge without a hearing, like they lose. So instead of being worried about the hearing, they should be really thankful that they have a hearing, because if they didn't have a hearing, they'd just lose, right? So
exactly. And that's what happens sometimes.
Yeah, absolutely. So when you're talking to them in the pre-hearing and you're going through evidence, what sort of evidence do you think is most important for your clients to be able to use to win their case? When you're looking at the case and you're talking through with them going, we're going to win your case, we need to show the court X. What is the underlying basis in that evidence that you're looking for, types of evidence that you are, to help them establish their disability so they can win their?
Well, number one, I always say the best sort of evidence that you can have is the medical records.
Sure.
Because you're having a professional sign on to the fact that you have, number one, like you said, the diagnosis. And 2, I try to help put those medical records in a context where it's about whether or not that person can work a full-time job. And a lot of time clients don't understand that it's not necessarily about not being able to work. It's not being able to work a full-time job. So medical records, number one. And there are all sorts of types of evidence that go into a file. And I know you've seen it too. We've got these disability reports. We've got their initial application where the client describes all these sorts of things. We've got third-party statements where somebody's signing on to what the client actually says. But, the doctor being the one is going to always be number one to me.
So let's talk about one of the things you said there, because you talked about third-party statements. In the development of the disability case at the early stages, they give you the ability to provide a third-party statement where you can explain, a third party, wife, mother, brother, cousin, sister, spouse, whoever, can explain why they believe you're disabled. And so one of the questions we get, and I know you get, is, well, my brother wants to testify, or my wife wants to testify, or we want to put on additional evidence. So I know from doing this a long time that this is not there's not general agreement in the disability bar about what you shouldn't put on third-party witnesses. What's your theory? Do you guys do it? If you don't do it, why not? If you do it, when do you use it? When do you use third-party witnesses? Can you sort of walk through this issue of having witnesses at hearing? Because even if your clients don't want to have one of their have someone come and testify on their behalf, a lot of times they're asking the question if they need to have someone.
Right.
Even if they don't have a witness, they're like, well, do I need to have someone come and testify? Because I could find someone,
Yeah. Well, it says it right in the notice of hearing. So that's usually one of the first questions I get. Do I need a witness? Should I have a witness? That sort of thing. My general answer is no. Right. I don't think that clients need a witness unless there's a situation where that client themselves cannot speak for themselves. And I use the term speak for themselves because we have all kinds of situations, all sorts of disabilities. And sometimes there are clients that may or may not know whether or not they can speak for themselves. But as a general rule, I don't really want witnesses in the hearing unless, they're going to give new information that the client can't give themselves.
Right. I mean, I think in terms of there's sort of clear incapacity with minors. If you have a child who's testifying, they clearly don't understand the import sometimes of their limitations, and you need a parent to testify. Certainly, we see people who have severe TBI, brain injury type people who really just can't cognitively navigate the difficulty of explaining in a hearing. Also, sometimes I know we've had some cases recently in the past couple of years where our client really needed a third party to
Oh,
talk
yeah.
about their mental health limitation because they didn't want to talk about it because they didn't want to acknowledge that they had the
Right.
mental
Flat
health
out refused
problem.
they had it.
Yeah, they refused to have it,
Yeah.
but the reality was that was why they were disabled, and so how
Right.
do you get over this hurdle? Obviously, you get it with a third party witness. So I hear you. That's generally
Yeah.
my opinion as well on third party witnesses. What are some of the things that can go wrong with third party witnesses in the hearing that maybe the clients don't think about? Demanding that you let their third cousin Johnny come testify because he's going to be the one who makes the case.
Well, third cousin Johnny may or may not know about what goes on with that client on the day-to-day basis to where they'd actually have knowledge to testify about
Sure.
their disabilities because that's what we want to talk about. The other thing that I've seen that comes up is sometimes, and I did this in the past, I allowed a husband and wife, I think it was the husband on behalf of the wife, and he sort of tanked our case
Yeah.
um, because they didn't know what each other was going to say.
Right.
And one, they may or may not agree with sort of the diagnosis or what goes on, especially in the house on a daily basis. Well, she can do that or he can do that or that sort of thing. So I don't want to do anything that I don't have control over.
Right.
And I only have and I have little control sometimes over my own client. So adding somebody new to the mix is always sort of a gamble.
Yeah, I think sometimes clients fail to understand too. One, usually the witness is sequestered, which means when you bring in the
Right.
third party witness, they're going to send your client
Yeah.
out of the
There's
room.
no
Uh,
winking and
yeah.
doing all that kind of stuff.
We had a client once where they used to do husband and wife hearings in the same day with the same judge. I don't know if they do that anymore, but they did. And I know we had a
I don't
case
think they
where
do.
the one spouse gave one testimony in the first hearing, and then we got to the second hearing, and the other one contradicted. And the judge was like, "Well, I'm going to pay one, but I'm not paying them both. They can't both be true. So figure out who you think's lying, and we'll pay
Yeah,
one, not pay the other." And not only that, it causes a lot of tension. Like
it
people
does.
sometimes don't understand that the fallout from that, because of the stress that's related to this disability case from having financial stress, and a lot of times
Oh, yeah.
marriages are they're stressed because of the disability itself, and to add this on there and have one of them blame the other one is just something that the benefit added probably doesn't exceed the risk of damage both
Yeah,
to
I
the
agree.
client as well as to the case. So I want to talk about a few other things related to hearings, but before we do that, I'll take a brief break so we can hear from our sponsor, CBIG.
Hey there, this is Kevin Rosenquist from the Disability Expert Podcast. Every week, Chad and his guests discuss the disability process and how expert attorneys help their clients obtain the Social Security disability benefits they deserve. But obtaining disability benefits is only half the battle. After winning your disability case, understanding Medicare should be your top priority, and that's where CBIG comes in. Disabled individuals must get their Medicare coverage right. Trying to understand Medicare can cause anxiety, uncertainty, and even fear. CBIG works with Medicare beneficiaries on disability around the country and is committed to helping those on disability navigate the complex Medicare process. Visit cbigcares.com today to see how CBIG makes Medicare simplified. Mention this ad and receive a free gift when you schedule a 10-minute consultation.
Okay, well, we're back and we're still going through issues related to hearings. And so I want to just hit a couple more. Let's talk about knowing who your ALJ is and knowing ALJ specific questions. Obviously, we don't always have that benefit, but
Right.
a lot of times when you're using a local lawyer versus using someone in a bigger national firm, you have this relationship with the judge, at least experience with the judge. How do you think that impacts cases? How can that be an advantage to your client? How do you think that relates to, for example, choosing your lawyer and who you should get to
Right.
represent?
It's a huge advantage, I would say. I practice in a lot of different places. I go to North Carolina, Georgia, South Carolina, usually all over the place, but I'm in the same places most often, mostly the Charleston, Columbia, Greenville area, because that's where the bulk of, our clients come from. I've been going in front of some of these judges for 10 years. So I know exactly what they're going to ask. Some of these judges, They're not great about switching up their questions. They will literally ask the same questions every single hearing that I've been in front of them. So it's a huge advantage to sort of know what the judge is going to be picking out of the medical records or picking out of the file and what specifically that judge is looking for. There are some judges that they're not going to approve certain types of cases. It's just not going to happen no matter what we go in there and say. Unfortunately, that's just the truth. But, knowing what they're going to ask ahead of time, I think also puts the client at ease, because that's really the biggest concern. What are they going to ask me? That sort of thing.
Yeah, for sure. A judge who will remain unnamed in Greenville that I used to go in front of was quite
I probably know who you're talking about when you start saying.
aggressive with clients at some level. And we did come across his questions at some point. We sort of figured them out. And you realize it's a huge advantage when you have that ability. Not that you're somehow cheating. It's just you're able to know this is what's important to this judge who is making this really important decision. So how do we prepare for that? But also knowing things that really bother them. So let's transition to this. So one of the things that comes up in preparing for hearings is dealing with bad evidence or negative evidence, work, drug, alcohol abuse. One things I think is hilarious is like when your client, you'll say, well, how's it going with your marijuana usage or whatever? And your client looks at you like, well, how did you know about that? And I'm like,
well, you told your doctor.
What do you think we're doing over here like for a year and a half? Reading the medical file, right? We get in these cases and you have bad evidence. It happens. There are I can't remember any cases don't have some evidence that's negative or isn't necessarily positive for their case. And it could be everything from, working and lying about work to something as innocuous as they had an ER visit where they said something off the cuff that made them look poorly. So how do you deal with negative evidence? How do you think your client should understand how you're going to deal with negative evidence? And how do you sort of fit that into the bigger picture of your case and trying to help your clients win?
Well, I call them red flags, Chad.
Yeah, for sure.
But it's built into my hearing prep. What I do is I sort of ask questions, sort of just see if they tell me first. And then I say, let's kind of go over some things that I found in the medical records that the judge may ask you about. My biggest piece of advice is to hit it head on, figure out a way to explain it, ask them about it so they can explain it to me first, and then I'll see how they can explain it to the judge. But the best way to deal with negative evidence is just to be truthful about it, in my opinion.
Yeah, I think sometimes clients fail to understand sort of this bigger dynamic of credibility where the reality is, well, if you're lying about something small that maybe even doesn't affect your case, how can I believe you when you're telling the truth about this really important issue where, I've in many cases said, well, look, my client was honest with you about probably the worst thing that we could talk about with respect to his case. That goes to his credibility. In fact, and then your job as a lawyer is to explain why this red flag isn't a big enough rationale.
Why it doesn't relate to whether or not this person can work.
Yeah, absolutely.
Whether or not this person is actually disabled. None of us are perfect. So I can figure out usually a way to sort of explain most of these things. But that's usually what I do is I hit it head on. And if the judge doesn't bring it up, I'm not necessarily going to bring it up.
Sure.
But if there's going to be something that we need to explain, then we will, I'll ask a question about it in the hearing.
Which also gets back to understanding who your judge is. A lot of times judges don't bring issues up, not because they don't know about them, but because it's not significant to them.
They're writing it right into that denial,
Or hopefully maybe they've just buried it away and this doesn't really matter. So that's a pretty good understanding of what's going on in a hearing and sort of these major issues that people deal with. And why do they need a lawyer though? Because a lot of people, they come in our office and it's, well, I know so-and-so down the road and they didn't have to have a lawyer and they got approved. And that's good for them. I'm glad that happened. But, I have just like you do, I have a full caseload because that doesn't happen. But why do you think, what's the benefit of having an attorney in navigating disability process, especially I tell people in light of how much is at stake in terms of both future income as well as, stability through your health insurance?
Well, if you're going to get denied, you don't have all the time in the world to correct that. So you want to put your best foot forward, I guess, in the beginning. But I think of it in two different ways. Number one, because we go in front of these judges so often and because we're dealing with the courts and that sort of thing, we're going to know how to prepare them for the case ahead of time. And we're going to know how to prepare the file so things don't get lost down inside, the court. And, that has to be corrected. The other part of it is the way that a judge will receive you if you have an attorney. I've seen judges schedule unrepped clients back to back to back and then give me an hour. So I think that it's really putting your best foot forward to have an attorney there on your side, because if I believe in your case, then that's going to make them believe in your case a bit more as well.
Yeah, it doesn't go directly to the credibility of your client, but the judges by and large recognize that we're not taking cases that are a complete waste of time because we don't get paid unless we win, right? So,
exactly. We don't want to waste our time, but we do care.
For sure. For sure. Well, thank you so much for being on the show. I'm so glad that you're here. I think your information's really helpful. I mean, obviously, a lot of people are unfortunately denied and they end up having to go to hearing. I think the insight you give is helpful to them. I think that those who listen and sort of take what you say to heart are going to have a better chance of winning their case. And obviously, if somebody needs help in Charleston, your firm's a call. So thank you again for coming on the show. Good seeing you again. And that'll be it. That will be a wrap on another episode of the Disability Expert Podcast. Be with us next week when we bring on one of the country's best experts. Thanks a lot.